On January 12, 2018, an extraordinary event took place in New Delhi. 4 sitting judges of the Supreme Court decided to hold a press conference in which they expressed their unhappiness at the manner in which the apex court was discharging its institutional duties. Among these 4 brave judges was Justice Madan Lokur, and we are honored to have him this evening with us to deliver the 2020 VG Verghese Memorial Lecture. Justice Lokur was touched on the shoulder in February 1999 and was inducted in the country's judicial elite. He began his innings on the bench as a judge of the Delhi High Court. He quickly earned a reputation as a steady and fair judge and was soon elevated first as Chief Justice of Guwahati High Court and later as Chief Justice of the High Court of Andhra Pradesh. In June 2012, he was called upon to join the Supreme Court as a judge. He retired on December 30, 2018. He is presently a judge of the Supreme Court of Fiji. As a judge of Supreme Court, Justice Madan Lokur has been the very embodiment of the finest qualities and venerable traditions of higher judiciary, displaying a quiet dignity, intellectual sobriety, judicial rectitude, unwavering commitment to the court's institutional dharma, and above all, a sense of obligation to strive continuously for creating and sustaining a fair and equitable society. Since his retirement from Supreme Court, Justice Lokur has lent his measured voice to our continued collective quest for a humane social order and a fair constitutional arrangement. It is therefore only fitting that this evening he should be meditating on the topic of preserving and protecting our fundamental rights, freedom of speech, expression, and the right to protest. A most contemporary theme, I should add. And as we have just heard from winners of the Chameli Devi Awards, it was never as difficult as it is now for citizens to express dissent, for activists and political cadres to exercise our right to protest, and for journalists to carry out the simple, basic task of a reporter, that is, to bring to light what is happening in our society and polity. Today, we are still trying to come to grips with what has happened in Hathras in Uttar Pradesh. Medieval animosities and prejudices continue to get privileged over notions of human dignity, and much to our dismay, because of electoral political calculations, we continue to find arguments and alibis to condone the brutal violation of basic constitutional promises and guarantees. What has happened in Hathras is just one ugly reminder, a very ugly reminder, indeed, of the mauling of republican virtues and democratic rights and liberties. Worse, we have been reminded once again of the state's capacity and its willingness to brazen it out, to come down heavily on anyone questioning its priorities and prejudices, and to demonstrate unapologetically its authoritarian proclivities. In all fairness, it must be noted that authoritarian itch never goes away. Sometimes it gets subdued, sometimes it goes into hibernation, awaiting the right moment to raise its ugly head once again. It is the task of conscientious public intellectual to keep reminding us of who we are, of what we have long ago committed ourselves to be, and more importantly, what we do not want to become. It is the task of public intellectuals like Justice Lokur to reiterate the details of constitutional compact and our social contract to build a fair society, an equitable social order, and a joyfully creative and questioning political culture. We must remind ourselves of our collective duty to remain unafraid of the minatory policeman, unintimidated by the overbearing magistrate, and uncompromising in our democratic beliefs and values. It is in this spirit, it is my pleasure now to call upon Justice Madan Lokur to deliver this year's BG Memorial Lecture. Justice Lokur.
Thank you, Harish, and good evening, distinguished guests. It is an honor to have been asked to deliver this year's Verghese Memorial Lecture. BG Verghese, or George to his friends and St. George to his admirers, was one of the most respected names in post-independent Indian journalism. He was also a classic specimen of the classic newspaperman anywhere in the world familiar with free press. A man of impeccable professional integrity, committed to society's well-being, and an editor unafraid of the powerful in and out of government. And it is most befitting that the Media Foundation keeps alive the values Verghese Saab cherished by way of an annual lecture series in his name. This evening, I wish to address a gradual erosion of one of our most precious fundamental rights, the inalienable right to freedom of speech and expression, an erosion that is leading to the gradual destruction of our human right to dissent and protest. This lethal cocktail is adversely impacting the liberty of all those who dare to speak up. Article 21 of our Constitution, the right to life and personal liberty, is under a silent threat, and we all know the consequence of losing our liberty. Simply put, we will cease to be a democratic republic. Of course, our fundamental rights cannot be absolute, and so our Constitution has placed a few reasonable restrictions on the right to free speech. Yet, it is important to note that these restrictions can be imposed only by law, enacted by Parliament, and the restrictions have to be reasonable. Our freedom of speech is being eroded and mauled through twisting and turning the law, if not abusing it altogether. The law needs to be objectively interpreted, but subjective satisfaction has taken over and the consequences are unpalatable. Dissent or expression of a different point of view has become an issue to the extent that bona fide speech sometimes becomes a security threat. Some cynics glibly suggest that if the speaker is not guilty, he or she will be acquitted of the charges framed. But the fact of the matter is that detention as an under trial is a gut-wrenching experience for anyone, and particularly for a person whose cries of innocence fall on deaf ears. Such a person looks to the judiciary for protecting his or her freedom of speech and liberty, but gets overwhelmed by the painfully slow justice delivery system. I propose to discuss our fundamental right of free speech and expression and the right to disagree in different compartments, and I hope the picture will reveal why we might need to conduct an inquest in due course of time. First, free speech and sedition. Ours is a country governed by the rule of law. So let us first appreciate what the law has to say on some aspects of freedom of speech. In my opinion, one of the worst forms of curtailment of the freedom of speech is charging a person with sedition. Way back in 1962, a constitution bench of the Supreme Court in Kedarnath Singh versus State of Bihar considered the constitutionality of sedition in section 124 capital A of the Indian Penal Code as a penal offence. While doing so, it was held that the freedom of speech and expression, and I quote, has to be guarded against becoming a license for vilification and condemnation of the government established by law in words which incite violence or have the tendency to create public disorder. A citizen has a right to say or write whatever he likes about the government or its measures by way of criticism or comment, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. The Supreme Court, therefore, drew a correlation between sedition and violence, sedition and inciting violence, and sedition and tendency to incite violence. Not just simple violence, but violence of such a degree as to bring it within the purview of public disorder. So when you have rival gangs confronting each other and one of them shouts, "Maro," a law and order situation of rioting and attempt to murder arises, not of sedition. The police, lawyers, and judges have dealt with all such cases purely as a law and order problem. However, depending on the occasion and context, when a speaker raises a slogan at a public gathering of supporters by shouting "Goli Maro," a charge could possibly be laid of tending to incite violence or incitement to violence and raising a public order issue rather than merely a law and order issue. The distinction is quite clear and should be clear to any policeman and magistrate. On the other hand, when there is a call to protest for a cause without any incitement to violence, it would not be sedition under any circumstances. For example, when a call was made for large numbers to assemble on the lawns of India Gate to protest against the rape and murder of Nirbhaya, the organizers of the protest were not committing sedition. Similarly, when India Against Corruption peacefully protested on the Ram Leela grounds, the organizers could not be held liable for sedition. This is extremely important for distinguishing between free speech and sedition, but unfortunately, the distinction is being lost sight of by the establishment. Frequent use of the law against sedition began sometime in 2012 during the India Against Corruption movement. Among the first few persons to be arrested for sedition was a political cartoonist who depicted the national emblem of 3 lions and the parliament building in a manner unacceptable to the establishment. Perhaps the idea was to keep that cartoonist in custody by hook or by crook, and so the charge of sedition was added. The law was obviously twisted to sustain this charge, since the cartoon did not incite or have a tendency to incite violence. But the objective was achieved, and the cartoonist was sent to jail for a while. Interestingly, in due course, the charge of sedition was withdrawn against him. But I will not be surprised if the incident had a chilling effect on some political cartoonists. Section 505 of the IPC was made use of against 2 young girls for a Facebook post in 2012. One of them questioned the need for declaring a holiday on the death of a political leader, and the other liked that post. At best, this was only an expression of an opinion that one may agree or disagree with. Unfortunately, both the young girls were arrested for creating or promoting enmity, hatred, or ill will between classes. So, the expression of a possibly unpalatable opinion became a criminal offense against the establishment. The Facebook post caused anguish among supporters of the political leader, and they vandalized the hospital of the girl's uncle. An innocent tweet led to 3 consequences: silencing the young girls and perhaps many others who held the same or a similar opinion, sending a chilling message to others to be careful about voicing opinions, and finally, imprisonment and damage to personal property. In one word, tweet at your own risk, a lesson that the Supreme Court sought to teach Prashant Bhushan quite recently. Second, free speech and cooked up cases. In recent years, new methods of silencing speech have been introduced. Attribute something to a speaker that he or she never said. I find this simply amazing. Try and visualize a police complaint filed against you for something you never said, and you are kept in jail for several months and eventually set free after litigating for your rights. Imagine the trauma that you and your family would have to go through, and on the other hand, the police gets away without even a censure. Well, this has actually happened. A doctor delivered an address to students of the Aligarh Muslim University criticizing the Citizenship Amendment Act and the National Register of Citizens. More than a month later, he was arrested for making an inflammatory and provocative speech. About 10 days later, he was granted bail but was not released for reasons that are not clear. However, immediately thereafter, he was kept in preventive detention under the National Security Act by an order issued on 13th February 2020. This is a draconian law and entails detention without trial and is based on the subjective satisfaction of the detaining authority who makes a prognosis of the future activity of the detenue. In other words, the detaining authority says that he or she is satisfied on the basis of past conduct that the detenue is likely in future to act in a manner prejudicial to the security of the state or to the maintenance of public order. By a judgment and order passed on 1st September 2020, the Allahabad High Court quashed the detention order. Almost every procedure known to law was violated. Additionally, on a limited judicial review of the grounds of detention, the Allahabad High Court concluded that the detenue was alleged to have said things which he did not. For example, while he spoke of national integrity, he was accused of promoting hatred. While he deprecated violence, he was accused of promoting violence. This is a classic instance of cooking up a case against a person with the intention of putting him behind bars for several months. Another recent case on the same subject of attribution is that of a student activist, accused, among other things, of attempt to murder and making an inflammatory speech and inciting violence. The offending speech was made by her on 25th February 2020, and she was arrested 3 months later on 25th May 2020. The Delhi High Court granted her bail after another 3 months by a judgment and order dated 1st September 2020. And while granting bail, it was noted that the prosecution had failed to produce any material that she, in her speech, instigated women of a particular community or gave a hate speech. Admittedly, the High Court said, agitation was going on since long. Print and electronic media was present throughout, in addition to cameras of police department, but there is no such evidence which establishes that the alleged offence has taken place on the act done by the petitioner, except some statements recorded under section 164 of the CRPC. These cases, and there are others, lead to a frightening inference that if a citizen exercises the freedom of speech and says something that is not even distasteful, yet he or she can be arrested on the basis of a fairy tale and will have to go through a long drawn process for being set free. If that person does not say anything at all, but is otherwise a thorn in the flesh of the establishment, even then that person can still be arrested and detained on some cooked up or trumped up charges. Please try and again imagine the impact of this, and if you are old enough, please compare it to the period between 1975 and 1977, when persons were jailed for allegedly threatening the internal security of the country without any evidence in this regard. We are gradually witnessing a somewhat similar situation. Third, free speech and fake news. How does one define fake news, and how does one distinguish it from misinformation or disinformation? How does one look at propaganda disseminated by the establishment? Is it fake news or misinformation or disinformation? Would it invite a charge of sedition against the purveyor of that propaganda? That question needs to be asked. A few tweets believed to be fake news relating to Kashmir have attracted a charge of sedition against a university student, and investigations have been going on against her for the last 1 year. The student tweeted to the effect that the army was entering houses at night, picking up boys, ransacking houses, and deliberately spilling rations on the floor. She also alleged that 4 men were called into an army camp and interrogated. Read tortured. The allegations were denied as baseless by the army, and it appears that it had closed the matter and no complaint was filed against her for the tweets. However, some public-spirited person lodged a police complaint alleging that this was a case of fake news that excited disaffection towards the government established by law and is therefore sedition. On this basis, the issue has been kept alive by the police for more than a year with no effective result as yet. The army has closed the matter, but the police is still at it. 3 questions arise from this episode. Can the tweets be categorized as seditious in light of the judgment of the Supreme Court? If the army, against whose credibility the tweets were directed, has dismissed the allegations and not lodged any complaint and effectively closed the matter, should a complaint by a third party at all be entertained by the police? Finally, does it take more than a year to analyze a few tweets to determine if they are seditious or not, or are police investigations being used merely to silence her? Similarly, a person in Punjab was charged with sedition for spreading fake news that ventilators were not available for COVID-19 patients in a particular district. Assuming this was not true, it could easily have been denied by the district administration. But foisting a charge of sedition on him? Contrast this case with another case of fake news, where no action has been taken against an elected cabinet minister who made a bizarre claim that a particular brand of papad provides immunity from the coronavirus. So far, no one has dared to officially contradict the cabinet minister, except the coronavirus, which attacked the cabinet minister and made him COVID positive, leading to his hospitalization. The pandemic has generated a tremendous amount of fake news in our country and worldwide. There is no doubt that fake news must be countered effectively and quickly. But surely, a charge of sedition is not the answer. Apart from a vague definition of fake news and its subjective interpretation, these cases show that the establishment prefers to act against the weak and defenseless with what was recently described as an iron hand rather than against the privileged who can get away by saying anything. The fundamental right of freedom of speech cannot be applied arbitrarily. Fourth, free speech and the press. In the last few years, the establishment has displayed a new determination and great ingenuity in securing conformity and obedience from the press. The cumulative effect is chilling. We all recall Mr. L.K. Advani's observation that during the emergency, journalists were merely asked to bend, but they chose to crawl. Today, there is no emergency, and nobody has asked the media to bend. Yet, the perception, may be wrong, is that they are crawling. There are two possible reasons. The first is a June 2020 report by the Rights and Risks Analysis Group, which recorded that, and I quote, a total of at least 55 journalists faced arrest, registration of FIRs, summons or show cause notices, physical assaults, alleged destruction of properties and threats for reportage on COVID-19, or exercising freedom of opinion and expression during the national lockdown from 25th March to 31st May 2020, unquote. These measures were taken in 20 states and union territories and included charges of sedition, promoting enmity among different groups, causing breach of peace, and so on. The second possible reason is that an unseen iron hand has been used to silence dissent and criticism. In May, an egregious case concerning the freedom of speech related to the arrest of the editor of a news portal. His alleged crime of sedition was spreading fake news by speculating that the chief minister of the state is likely to be replaced for his inept handling of the pandemic and thereby exciting disaffection against the government. In this particular case, while rejecting the application for bail, the magistrate is reported to have said that the journalist was trying to destabilize the government, and what he said was a contempt against the government. Fortunately, the higher court granted him bail, but after he had spent about 15 days in custody. In June, a senior and respected journalist had a sedition charge leveled against him for a YouTube show and had to petition the Supreme Court for staying his arrest. The allegations may have been reckless or bizarre as they have been described, but the question is whether they can be classified as seditious given the law laid down by the Supreme Court over 50 years ago. The chilling message to the press is to crawl or else. Just a few days ago, the horrible gang rape and murder of a young girl in Hathras resulted in another and rather ingenious method of restricting the freedom of the press. With a view to prohibit the media from reporting anything about the events, the establishment completely cordoned off the entire area with about a few hundred policemen and issued a prohibitory order under section 144 of the CRPC so that nobody could enter the area. Some intrepid journalists attempted individually to meet the family of the victim without violating the prohibitory order, but was stopped from doing so on the basis of some undisclosed order said to have been passed by some higher-ups. This is nothing but an egregious violation of the freedom of the press through a bizarre abuse of the law. Everyone is hearing and seeing what is going on, but is anybody listening? The other question to be asked in this context is, can any serious journalist function fearlessly if an opinion expressed, however absurd or bizarre, leads to arrest and a charge of sedition, followed by a long-drawn battle in the courts? Can such serious charges be leveled so casually? And remember, a free press is the fourth pillar of democracy. Fifth, weaponizing the sedition law. The National Crime Records Bureau started keeping a record of sedition cases in 2014 and every year has seen a spike in sedition cases. The number reached a high of 70 cases in 2018. Figures for 2019, recently released by the National Crime Records Bureau, revealed that 93 cases were registered. That is about a 30% increase. Almost every state seems to have weaponized sedition as a means of silencing critics, and the numbers are increasing. Any statement is good enough for a sedition case. And this is not just in a few states, it is in almost every state and union territory. On 31st October 1984, the day Mrs. Indira Gandhi was assassinated, two public servants shouted, "Khalistan Zindabad." The atmosphere in the country was charged, and yet the Supreme Court held that this did not amount to sedition. The Supreme Court held, and I quote, "It does not appear to us that the police should have attached much significance to the casual slogans raised by two appellants a couple of times and read too much into them. The casual raising of the slogans once or twice by two individuals alone cannot be said to be aimed at exciting or attempt to excite hatred or disaffection towards the government as established by law in India." How things have changed since then. In an absolutely peaceful atmosphere, a teenager in Bengaluru raised a particular slogan 3 times, and this resulted in her arrest on charges of sedition. Could this ever amount to destabilizing the government? But this teenager spent 4 months in jail before she was granted bail. Again, in Karnataka, as many as 85 school children were interrogated by the police concerning a play in which a child recites what the authorities found to be an objectionable dialogue. The mother of the child and the teacher who oversaw the play were charged with sedition and arrested. Please try and imagine the trauma that the school children would have gone through with policemen and policewomen questioning kids over 5 days in school. And while we are discussing destabilizing the government, does horse trading of MLAs, let me be clear, this is not my expression but one used by the Supreme Court. Does horse trading of a few MLAs with the view to topple a duly elected government amount to sedition? Perhaps. In July, the Special Operations Group in Rajasthan filed FIRs against 6 MLAs for sedition, because they had indulged in horse trading with a view to topple the government. However, just before the High Court was to take up the challenge to the sedition charge, the allegations were withdrawn. A pity, because it would have been a fun case. 6th, free speech and the internet. District or statewide internet shutdowns are becoming a tool to stifle freedom of expression through prior restraint. Shutdowns are effected through blanket orders under the guise of preventing breach of peace. In most cases, they are deployed when the authorities apprehend that people may exercise their fundamental right to freedom of expression to organize a peaceful protest that is critical of the state. An internet shutdown is a highly disproportionate response since it affects everyone who uses the internet for professional reasons, for communicating with family or friends, for access to education, medical facilities, and so on. In December 2019, there was an internet shutdown across all districts of Assam, and mobile internet was suspended for almost a week. While striking down the shutdown, the Guwahati High Court noted, mobile internet services now play a major role in the daily walks of life. So much so, shutdown of the mobile internet service virtually amounts to bringing life to a grinding halt. The High Court then directed the state to restore mobile internet services with effect from the evening of the same date. In Allahabad, the High Court took suo motu cognizance of the internet shutdown imposed in the city and while issuing notice observed that stoppage of internet services has paralyzed the entire judicial system. In Anuradha Bhasin's case, the Supreme Court in January 2020, while deciding the legitimacy of internet shutdowns as well as physical lockdowns in Jammu and Kashmir, stopped short of declaring access to internet as a fundamental right, but declared that the right to freedom of speech and expression under Article 19(1)(a) and the right to carry on any trade or business under Article 19(1)(g) using the medium of internet is constitutionally protected. In September this year, the Kerala High Court recognized that access to the internet is essential for not only exercise of freedom of speech, but also the right to education. It was noted that the United Nations Human Rights Council had declared that right to access the internet is a fundamental freedom. We have the unenviable record of stifling freedom of speech and expression through maximum number of internet shutdowns and for prolonged periods in any vibrant democracy. In conclusion, I would say that there is no doubt that the fundamental right to free speech is extremely important for any civilized democracy to survive. Similarly, the right to protest peaceably and without arms is also an equally important fundamental right guaranteed to all of us under the Constitution. While it is important for each one of us to exercise our fundamental rights within reasonable limits laid down by law, there is a greater obligation on the establishment to ensure that the laws are not twisted, misused, or abused in such a manner that citizens are deprived of fundamental rights that impact on the liberty of an individual. We have seen several instances of deprivation of liberty with persons having to spend days and sometimes months in jail for remarks that would perhaps not attract any attention, except for the fact that the establishment used draconian laws to silence those dissenting voices and thereby give them traction. It is time for the establishment to realize that the people of this country mean well. And as in any democracy, there are bound to be different points of view. These must be respected. Otherwise, the fabric of our society might disintegrate, and fraternity, one of the key words in the preamble to our Constitution, might just become another dead idea. Thank you and God bless.
That was most illuminating, Justice Lokur. Thank you. We are in your debt for this evening's powerful dissection of the law and its interpretation and its implementation. I am confident that your reflections will deepen our understanding and will go a long way in helping the citizens assert their legitimate rights and reassert their right to protest and right to have their voice heard. We appreciate you taking so much time out for us. In fact, indulging us twice, once last March and now this evening. On behalf of Media Foundation, I express our profound thanks. I also take this opportunity to put on record our immense gratitude to Shri Ashok Bajpai and the Raja Foundation for so generously supporting activities of the Media Foundation in defense of creative freedom. We are also thankful to India International Center, especially its program division, for hosting us this evening and for continuing partnership with the Media Foundation. And I'm grateful to all my colleagues, Ms. Manika Chopra and others for joining, making the collective effort for the success of this evening's prayer. Thank you very much. Good evening.